A very warm welcome to my students of BBA Section A and Section B. This is the first lesson that we will be seeing for understanding the law. We've already discussed a few of these points in the class, but this one lesson will be a bit of a revision as well as an opportunity to introduce you to a few new points. When you watch this video, make sure that you realize that this is a video and therefore you can pause this whenever you like. Okay? You can also rewind this and listen to it again. Also, in case you find me too slow or too fast, you can alter the speed of the video, right? So that is the luxury of having this lesson as a video. This video will have a lot of information, so feel free to pause it when you like, and don't worry if you don't understand all of it. Even if you can get, say, 30% or 50% of what is being saying, that is enough. Of course, if you can get more the merrier. Okay, let me give you an idea of what we will be seeing in today's lesson. All right, a brief outline of what we will be studying today. We will start off with a few preliminary concepts that we've already dealt with. We'll have a look at what a legislation is. Then we'll see as to what a judgment is. We'll go ahead and understand in some greater detail as to what a law is. Okay, once we're done with that, we go and have a look at the Constitution. Okay, we've already seen that the Constitution is the fundamental law of the land. So what does that imply? Within the Constitution, we'll have a look at some of the more important provisions. Once we are done with that, we will have a look at this very important concept in the Constitution, the concept of an amendment. Thereafter, we have a look at the judiciary of India. There are some points that we need to know about the judiciary, the independence of the judiciary and why it is so important, understanding the hierarchy in the judiciary and the hierarchical structure. We need to understand as to why there is a need for interpretation and what the role of the judiciary is in interpretation. Okay, the interpretation of statutes. And then we'll also discuss about the judiciary as being a body that resolves disputes. Finally, we will talk a bit about the Supreme Court. Okay, the Supreme Court as the final interpreter. Okay, the Supreme Court consists of a bench. Definitely, you've heard of what a bench is. We've discussed this briefly in the class as well. I will talk about it in a little more detail today. And then finally, I'll talk a bit about the action of the Supreme Court striking down a law. Okay, now that we know what we will be doing in today's class, let's proceed. We will start with the preliminary concepts. Okay, the first amongst these was that of a legislation, right? So we will look at what a legislation is. A legislation, very simply, is an act of the legislature. What do I mean by that? An act of the legislature is a legislation. So if you ask me, what is the legislature? Well, the legislature is the body that passes the legislation. Very simple. Now, when I say act, I am not referring to an action. Okay, I'm referring to an act with a capital A. Very important. Okay, so this is like Indian Contract Act, right? It's very important to write this with a capital A in the uppercase. Likewise, you have the Indian Penal Code, which is also an act. You must remember the Indian Penal Code is also an act, but it is called the Indian Penal Code. You have the Companies Act. All these are legislations. In fact, it is important for you to know that the Constitution of India is also a legislation, which is an act of the legislature. Now, with regard to the legislature, I want to tell you a few points. In case you find this a little complicated, don't worry. When I say legislature, we have legislatures that can operate at two levels. The one is at the center, the second is at the state. Okay. The legislature at the center is called the parliament. Very simple. So we have legislature, I told you. The legislature at the center is called the parliament. So if anyone asks you, or if you have to say again as to what the parliament is, well, the parliament is the union or the central legislature. What does the parliament consist of? The parliament consists of three things. It consists of the Lok Sabha. This is the first thing. The second thing it consists of is the Rajya Sabha. Surely you have heard of these two terms. And third, and many people often forget this, it consists of the President of India. So these three people together constitute the Parliament. The Lok Sabha is called the lower house, and the Rajya Sabha is called the upper house. Very simple. If you've learnt just this much, it is more than enough. I'll talk a bit about the state just for your curiosity. Okay. At the state, you can call this just the state legislature if you want to, the state legislature. Now, the state legislature in most of the states of India consists of only one house. Here you can see there are two houses, right? There are two houses in the center, the lower and the upper. In the states, in most states, there is only one house. That house is called the State Legislative Assembly. Legislative Assembly. Okay, very simple. So, who is an MLA? An MLA is a member of the Legislative Assembly. So simple. What is the meaning of MP? MP means Member of Parliament. I hope you've understood all of this. So, you know who an MLA is? A member of the Legislative Assembly is an MLA. So, I said that in most states, you have only one house, but in some states, you have two houses. Is that okay? In some states, you have two houses. So you have what is known as the Legislative Assembly. The other one is called the Legislative Council. Okay. Now, amongst these two houses now, the Legislative Assembly becomes the lower and the Legislative Council becomes the higher. This was a little complicated. I know that. I'll just repeat this once for you. Don't worry. And even if you've not understood it, it's not a problem, but I'll just repeat this once for you. Okay. So we said that we have the legislature at the center. At the center, it is called the parliament. Very simple. The parliament consists of three people, right? What are those three people? I mean, not three people, three entities. The first entity is the Lok Sabha. The second entity is the Rajya Sabha. The third person is the president. Simple. Lok Sabha is the lower house. Rajya Sabha is the higher, or rather the upper house. We don't call it the higher house, we call it the upper house. Simple, very simple. All right. At the state, I said, see, there are two kinds of states. In some states, there is only one house, that is the State Legislative Assembly. So, when there is only one house, there is no question of upper or lower or upper. But in some states, there are two houses. So, the lower one is called the Legislative Assembly, the upper one is called the Legislative Council. Very simple. So MLA means member of Legislative Assembly, MLC means member of Legislative Council, MP means member of Parliament. So simple. So I hope with this you've also understood what an MP is, what an MLA is, and what an MLC is. Very simple. All right, let's go ahead. With regard to legislations, I had told you that legislations are also called acts. Legislations are also called statutes. Okay. So if I use any one of these words, you must know that these can be used interchangeably. What that means is you can use either of these words to address an act. Let's say, for example, if I say the Indian Penal Code, IPC, Is it an act? Yes. Is it a statute? Yes. Is it a legislation? Yes. The Constitution of India, it is a legislation, it is an act, and it is a statute. Good. Let's proceed. Now, what is a judgment? Okay. You see, there is a dispute between two people, and you go to the court, and there has to be a decision, right? But what is a decision without reasons, right? So the court, when it gives its decision, also gives you the reason. Briefly, you can understand that this is what a judgment is. Okay. And when we talk of the High Court and the Supreme Court, then these are what are known as courts of record. You know what that means? That means they keep a record of all of their judgments, which means they keep all of their judgments. They're very important because these judgments become the law of the land. Okay. So, record of all of these judgments is kept. Okay. So, that's what the significance of a judgment is. Now, you might appreciate that judgments are often very long, right? If you've opened a judgment ever, then you would have seen that judgments can often run into hundreds of pages, right? So now within a long judgment like this, within a lengthy judgment, we look for this. Now, what is this? Well, this is a bit of Latin. Lawyers do that often to sound smart. It is called the ratio decidendi. Okay. What is the meaning of ratio decidendi? Well, I would say it is the rationale. So you can think of it like this: the ratio is the rationale. There is a jurist. I use the word jurist. You know who a jurist is? A jurist is, well, a legal scholar. Okay. A legal scholar, someone who is very good at the law academically, is a jurist. Okay. So there's a jurist by the name of Professor Goodhart. Why am I telling you this? I'm just telling you by the way. Okay. It's good to know a couple of things. That's why I'm telling you. So this Professor Goodhart, who is a jurist, so you've learnt a new word, jurist, along with this word that's called ratio decidendi, says that the ratio decidendi is basically the material facts plus the decision. Okay. So you see, in every case, there are many facts. The material facts means that we're looking at the main facts. Okay. So in the judgment, I told you, in the judgment, they write their decision with reasons and that they are very lengthy. Now, within this lengthy judgment, you pick only two things if you have to. Okay. What are the material facts, which means what are the main facts? And thereafter, what was the decision? Who won? Who lost? These two things together are what are known as the ratio decidendi. Okay. This I can say is the main part of the judgment. Okay. Now, so we saw that there's a judgment and that the judgment is very large. Okay. It's very big. Now, within this judgment, I said this there's a small part which will give you the material facts plus the decision, which is what we saw is called the ratio decidendi. We sometimes also simply just call it the ratio. Okay. So basically what we learned is that this little part here is the ratio of the decision. Now, what about the rest of it? You see, there's a lot more left. What is this part? Right? What is the rest of the judgment called? You guessed it right. The rest of the judgment is perhaps called the obiter dicta. Very simple. So the rest of it is called the obiter dicta, which means that your judgment, which is very long, consists almost entirely, you can say, one of the ratio which is the ratio decidendi. I'm now calling it the ratio. Likewise, the obiter dicta can just be called the obiter. So these are just fancy names for you to learn two new concepts of what is a ratio and what is the obiter. All right. So now you know as to what you will find in a judgment. As you get more experienced with reading judgments, you'd be able to identify the ratio. You see, now let's say there's a judgment. Okay. The judgment now goes on into several pages. Let's say this is one page. Okay. And then you have your next page here. You will never find a title that, okay, now we will discuss the ratio. Now we are doing obiter. You don't see it like that. It is just paragraph after paragraph after paragraph. With time, you learn to identify, okay, this is a part of the ratio. This is the ratio. And then you realize, all right, this is obiter, this is obiter, this is obiter. And then you just basically identify as to what the ratio is. Okay. Very simple idea. Ratio, main part of the judgment, obiter, some things that were spoken in relation to the case, but they were not the main things. Long story short, judgment consists of the ratio and the obiter. All right, move forward. What is law? Okay, I'll talk about a few types of law. All right, if I am asked as to what law is, perhaps one way of defining the law is that it in some ways identifies collective conscience, right? We all have a conscience, an individual conscience, an inner moral compass of what is right and what is wrong. We also have a collective conscience, which means that what do we all think together as a collective, as a group, as a class, as a tribe, as a country, right? So the law in several ways represents or is meant to represent the collective conscience. Okay, I'll talk of a few types of law. The first is the parliament made law. Now we remember what the parliament is. What is the parliament? The parliament is legislature, the legislature at the center. So we know that the parliament made law is what we call the legislation. So simple. A legislation is also called an act or is also called a statute. Very simple. So we know what parliament made laws are. This is the first kind of law. All right. Next, we look at judge made law. What do I mean by judge made law? You see, I said that when a court pronounces a judgment, right, we keep a record of it because what has been said by the judge in his judgment is also the law, right? So, in the judgment, I said there are two parts. The first part is the ratio decidendi, which I will just call the ratio, and the obiter dicta, which I will just call the obiter. It's important for you to know that this ratio is also the law of the land. So, like I said, this is the second type of law. So, you remember, we are looking at what law is. First type, parliament made law. Second type, judge made law. All right. Well, is there any such thing as a God made law? Well, what I'd say for this is that there are a few things which are governed by religion, right? I got the spelling wrong, religion. There's an extra O. Okay. So, God made law, well, it is a law. Perhaps before, let's say, before you had these judge made law and parliament made law, you had God made law. Let me call that the third type of law. Okay. Today, God made law is not very significant. So perhaps what your God has prescribed for you, what your religion has prescribed for you, is not of as much significance today as perhaps the judge made law and the parliament made law. But still, this religious law, which is sometimes operational and what is known as the personal law is still functional. Let's say, for example, in marriage. Okay. Now, when you take, say, the 7 steps around the fire, that's a ceremony. Now, that ceremony is related to the law, the personal law of the Hindus, but that is also accepted as a part of the law. The ceremony is accepted as a part of the law. Similarly, when you talk of, say, talaq, okay, this is also something which is incorporated into the law, but it has its roots in religion. So, what I want you to know is that religion does have a part in contributing to the law. Do not forget that there also exists God made law, although less, it is perhaps less powerful, it is less influential, it is less pronounced, yet God made law exists. I just want you to remember that. Finally, I want to talk to you about the fourth kind of law that we often forget: customs and practices. Let us say we've been doing something for a very long time, for a long time. Okay? By long time, I mean a really long time, which is what is called since antiquity. Remember this word, it's a good word. It means something done for a very long time. If you're doing something for a very long time, then that becomes a custom and a practice. And you know what? When you do something for a very long time, it acquires the force of the law. I will write this down for you. It acquires the force of the law. Okay? Which means if you do something for a very long time, and if the law of the land recognizes it. So if there's a custom, plus, let us say the parliament or the court recognizes it. If it is recognized by the parliament or by the court, then even customs and practices become law. All right, so do not rubbish a custom just because it's a custom. Things which have been done traditionally can also become the law. All right, so what we've seen is that with regard to law, we have 4 types of law. Okay, the first and the second are more important, of course. These are the more important laws. However, we also do have these sources of law, 3 and 4, religion, customs, and practices, which also make up the law to some extent. Now, we will talk about the Constitution. With regard to the Constitution, we had discussed that the Constitution is the fundamental law of the land. You may remember this diagram. Take a moment to recollect what I had said about this. The Constitution is the fundamental law, right? It is the basic law from which all other statutes derive their significance. What I mean to say is that I said that the Constitution is also an act, the Indian Penal Code is also an act, the Indian Contract Act is also an act. Then what is it so special about the Constitution that I am talking about the Constitution separately? What is it about the Constitution that makes it a fundamental law? Well, the significance of it is that every other law, and when I say law, I gave you 4 sources of law. Remember this, right? When I say law, do not think only of statutes because that's only the first kind of law, right? So every other law derives its sanctity, okay, from the Constitution. Simple. What I mean to say is that the Constitution is the fundamental law all the other laws are in a way built upon the Constitution. Or I can say it is premised on the Constitution. These are just different ways of saying the same thing. If you understood the diagram, you understood the point. The rest of it is just verbal diarrhea. All right. If you understood the diagram, you understood the point. I'll just proceed. As a law student and as a bit of a law teacher, I am kind of predisposed to talk more than what is necessary. So just ignore it if you find it superfluous. Now I want to talk about this point that is called constitutionality. We've discussed this before. Let us say there's a certain law. Okay, the law is, let us call it the Indian Penal Code. Okay, now there could be this law which has a certain, the Indian Penal Code could have a certain provision. Let us say section number 100. I'm giving you only an example. Section 100 is not what we're talking of right now. I'm just giving you an example because 100 is a simple number. Now, what if section 100 is not in accordance with the Constitution? What happens? We always check, therefore, every now and then, whenever there's a dispute, the constitutionality of a provision. When I say we check the constitutionality of a provision, what that means is that we see that, let us say, if there's a given provision here, let us say section 100 of the IPC, is it in accordance with the Constitution? Is it in accordance with the Constitution? What is the meaning of accordance? Accordance is basically to say, is it according to the Constitution? This is the question we ask. And this is what we identify as the test of constitutionality. The fact that we check the other laws on the basis of the Constitution is what is known as the test of constitutionality. With this, I hope you understand as to how significant and important the Constitution of India is. Next, I was to talk to you about some important provisions. As you can see, there were three things that we were to discuss about the Constitution. So now I'll talk about some important provisions in the Constitution, right? Talking about the important provisions, let me tell you why we need to talk about the important provisions. The Indian Constitution is one of the longest written constitutions of the world. Okay. So, in its original form in 1950, the Constitution of India had around 395 articles. Okay. But today, with the passage of time, today, let's say when we talk of 2020, it has perhaps 470 articles. Okay. Which makes it very bulky, right? So what we need to know is that we will look at only some of the important provisions in it because we obviously can't learn all of these. Amongst all of the the provisions in the Constitution, I would like to draw your attention towards fundamental rights. Okay, fundamental rights are contained in Part 3 of the Constitution. Part 3, you can call it like it's like a chapter. Okay, Part 3 of the Constitution contains the articles starting from Article 12 to Article 35. Okay, you find your fundamental rights given to you in Articles 12 to 35. We discussed this in the class. What are fundamental rights? I'll call fundamental rights FRs. Okay, now what are these fundamental rights? Fundamental rights are basically fundamental human rights. What are human rights? Human rights are the rights for humans. Okay, but out of all of the human rights, so let us say this is human rights. Okay, out of the human rights, some of them are the most important human rights, and those most important human rights are the fundamental rights. So we saw that there are many laws. The fundamental law is the Constitution. So we have many human rights. Amongst those human rights, the most important amongst them are what we identify as the human rights. Okay? So remember that we have animal rights as well, we have plant rights, we have biodiversity rights. So basically, out of all of the rights, let me show you once again diagrammatically. Some of you might remember that we've done this. Rights can belong to humans, or rights can belong to non-humans, right? It can belong to birds. Don't birds have rights? Don't animals have rights? Okay. Amongst the human rights, we have some fundamental rights, which means we have some other non-fundamental rights as well. Okay. For example, you have a right to property. It is not a fundamental right, but right to freedom of speech, well, that is a very basic human right, and therefore you find it in this chapter relating to fundamental rights. Fundamental rights, where do you find it? You find it in part 3, where between section 12 to section 35. Very simple. Okay. Now, you might remember that I had spoken of a golden triangle. When I spoke of a golden triangle, I told you, so we have the entire constitution. Okay. We narrow it down. From the entire constitution, we spoke about fundamental rights. Okay. Fundamental rights are from sections 12 to 35. But these are also many sections, right? Many articles. Sorry, I should not say sections. These are many articles. Okay. If I say sections when talking about the constitution, you must remember that I made a mistake. Always say articles for the constitution. Okay. I have the habit of sometimes saying sections, so forgive me for that. Okay. Out of all of these, as you might see, these are 24 articles in here. That's quite a bit, right? Out of these 24, there are three very important provisions. So what did we do? We have a total of 470 articles. Out of that, I said, let's look at the fundamental rights. But the fundamental rights are also 12 to 35. I said, let's look at the most three important provisions from these. And these are what we call the golden triangle. Okay. And these are the three provisions that you need to read by yourself. I have not displayed it here for you because that is what you need to do by yourself. Article 14, Article 19, and Article 21. Okay. So I don't expect you to know everything. You need to see only a few provisions, and I've explained this to you in the class. Therefore, you are expected to Google these, read Article 14, Article 19, and Article 21. In brief, Article 14 gives you the right to equality. Article 19 gives you the right to freedom. What kind of freedom? The freedom of speech and expression, the freedom to assemble peacefully, many other rights to reside anywhere in the country. You get a lot of freedom from Article 19. And then there is Article 21, which gives you what is known as the right to life and liberty. So these three provisions are very important. Make sure that you learn these. Now I'll talk a bit about amendments. Okay. It is said about the Constitution that the Constitution is not a dead document. It is not a dead document. On the contrary, it has been described. I'm talking about the Constitution. Okay. So the Constitution has been described as not being dead, but instead it is called a living, vibrant, and dynamic document. What that means is that it caters to the needs of today. It is not something which is dead. It is not something which is static. It is not static. As you might understand, the grammatical opposite of the word static is dynamic. Dynamic means that it changes, it adapts. It adapts itself to the requirements of the present day, right? So with the passage of time, the requirements of the society keep changing. So the Constitution is a dynamic document that adapts itself to the needs, requirements, aspirations, and expectations of the present day. Okay. Now, how do you do that? Let us say we have to adapt this and we have to change it. Well, that is essentially what an amendment is. The amendment means is basically a change that can happen in the Constitution. Basically, any law can be amended, but I'm talking only about the amendment of the Constitution. Okay. Remember that even the IPC can be amended and has been amended. Even the Indian Contract Act can be amended. Remember all of this, but I'm talking about the amendment of the Constitution. Okay. Now, remember, who is the Parliament? The Parliament is the person who enacts the laws. Remember? So you said that the Parliament is the legislature. If you remember, what does the legislature do? The legislature enacts a legislation. I said it makes a legislation. A better word for making is enacts. Okay, so the Parliament enacts a legislation. Okay, the amendment is also done by the Parliament. So we learned a new thing, that let us say there's a certain article. Let us say there is Article 100. Okay, and we feel that okay, Article 100 is no longer needed for us and it needs to be removed by an amendment. Who does it? The Parliament does it. Okay, now when you want to amend, it means you want to change, right? An amendment is a change, and an amendment can be done in a few ways. Okay, so an amendment, which is basically a change, can happen in a few ways. The first thing that can happen is you may repeal. You know what the meaning of repeal is? You may altogether repeal the whole statute. The whole statute. For example, let us say today we have an Indian Penal Code. You can just remove the whole statute. Like, okay, from tomorrow there is no Indian Penal Code. That would be a repeal. Okay, you can repeal the whole damn statute. That's possible. That will be called a repeal. Okay, that's in a way I will not call that an amendment because it is not a change, it is a complete removal. Therefore I will not talk of repeal as change because repeal is to completely remove. But let us say we retain the document. Let us say the IPC remains, but you want to bring about some changes. Let us say you want to remove one provision. You want to delete, say, section 100, or you want to delete article 100 from the Constitution. Okay, you can do that. You can substitute, let us say, first section 100 of the IPC read as, let us say it had this. You believe that this is not good and you want to replace it by something else. So what you do is you substitute section 100 by something new. Okay, this is possible. It is possible for you to add, which is to call, which means that you insert. Let us say between section 100 and section 101, you want to insert a new provision. You know how you can do that? You can insert what is known as a section 100A, right? So let us say it's like a book, very simple. You have your chapter 1, you have chapter 2 in your book. Now let us say someone wants to put in a new chapter. What does he call it? He calls it chapter 1A. That's exactly what has happened here. So we know that amendments can happen in a certain way by the Parliament. One important fact that I'd like to tell you about the amendments to the Constitution. Our Constitution has been amended 104 times. Okay, the Constitution of India has been amended 104 times. All right. Okay. Now we get to the final topic for today's discussion, which is the judiciary. When I talk of the judiciary, I'm basically talking about the courts in India. This building is basically the Supreme Court of India. Okay. When I talk of the judiciary, oh, so did I say this is the last section? It's not. This is the second last section. Okay. I'm talking about a concept here, a few concepts. We'll begin with the first concept, which is that of the independence of the judiciary. You may have heard this word a lot about the independence of the judiciary, right? It's often spoken of. I'll discuss this with you now. What is the significance of the independence of the judiciary? You must have heard that there are three pillars of the government. Do you see this fourth one here? The fourth one, which is kind of half there. Well, sometimes people say that the media is the fourth pillar, all right, or it's sometimes called the fourth estate. But largely, we have three pillars: pillar number one, pillar number two, and pillar number three. Of course, there's no such thing as the first, second, or the third. We have three pillars. The three pillars are what are known as the executive, legislature, and judiciary. There's no such thing as this being the first. I can even say that the first is judiciary, second is executive, and third is legislature. There's no such thing as an order. Okay. But the fourth always refers to the media. All right. Remember, when you say fourth estate or the fourth pillar, that surely is the media. Okay. But as far as these three are concerned, you can use them interchangeably. There is no need to say that the executive is the first pillar. Okay, the fourth pillar is the media. I'll tell you very briefly as to what these pillars are. Okay, you know what the judiciary is? The judiciary is the system of the courts. The legislature is what I have told you. So let's say, suppose this is the legislature. The legislature, you know what the legislature does? It makes legislations. Then there is the executive. The executive is the another limb. I can call it a pillar, or I can call it a limb. Okay. The executive is basically what implements the legislation. For example, your police officers are a part of the executive. Your bureaucrats are a part of the executive. Everybody who implements is the executive. And then you have the third pillar, which is the judiciary. Now, when you say independence of the judiciary, what that means is that these two pillars, right, should not influence the judiciary. It's a very important point. These three pillars have to be independent. This is what is required so that you can have a free, fair, and impartial trial. Let us say the judiciary were influenced by the legislature, or if it were influenced by the executive. What happens is that it is not possible for the judiciary or the judge to be impartial, which is why we say that for justice to be delivered or for justice to be met, the judiciary should be independent. All right. So I hope you understand what the meaning of independence is. Independence means that it is independent of any pressures from the other pillars, so that it is possible for it to impart free, fair, and impartial justice. This is also known as separation of powers. Like I said, I give you new words for the same thing. Not exactly the same thing, it's slightly different. If you're curious enough, you can go ahead and Google this doctrine of separation of powers. I said doctrine of separation of powers. What is this doctrine? Doctrine is nothing. Doctrine is basically rule, but rule sounds very simple, and lawyers like to use words that are not simple. Therefore, we call it the doctrine of separation of powers. Simple, very good. So we basically know that there should be independence of judiciary. Now we're talking about the second point, which is about hierarchy. Okay, when I talk of the hierarchy of courts in India, you're already aware of it, but I just thought I'll repeat this for you. In India, we have a single unified judiciary. Remember this? We have a single unified judiciary. Okay, that's why I have shown all of these three on one diagram, because there is a single unified judiciary. However, as you can see, there is a certain hierarchy. At the top, we have the Supreme Court, which is why sometimes the Supreme Court is also called the apex court. You know what the meaning of apex is? The meaning of apex is the highest point, right? So, in fact, when you have a mountain, you call this the apex, right? The peak. Okay, so the apex court is the Supreme Court. Below the Supreme Court, you have the High Court. And below the High Court, well, I have not given you a detailed lists of what you have below the High Court, but you can kind of say that it is the District and the Sessions Court. You can Google these. Um, I'll give you a little detail. Don't bother about it. If you don't get it, just let it be. It's not required for you. The District Court deals with civil matters, and the Sessions Court deals with criminal matters. Don't worry. For the time being, you can just remember that these are lower courts. Now, why am I telling you all of this? I'm telling you this because there's something called appeal. Now, let us say you went to the lower court first. Obviously, you go there with a certain dispute. Now, the court could either decide this way or it could decide this way, right? The decision can either be yes or it can be no. Let us say the court says yes. Now, you don't like it. So, what do you want to do? You want to go and appeal. So, you go in, appeal to the High Court. Now, again, the High Court could either say yes or it could say no. The High Court also says yes. So, you're still not satisfied. So, you want to go to appeal to the Supreme Court. Again, the Supreme Court could either say yes or it could say no in your appeal. Okay. Now, let us say the Supreme Court says no. Now, you've got your decision in your favor. This decision will override the decisions of the lower courts. That's why I said in the hierarchy of the courts, the Supreme Court is at the top, right? So, the decision of the Supreme Court will prevail over the decisions of the other courts. So, the Supreme Court said no, this is the winner. What the High Court said and what the District Court said does not matter. Okay, the Supreme Court is the final deciding authority. This is a bit about the hierarchy of the courts in India. Now I'll talk about interpretation. You see, if you remember, I had told you that the meaning of a law is gathered from its context. Very important point. The meaning of the law is gathered from its context, which means that we go beyond the black letter of the law. You cannot mindlessly read the law, right? So when you apply the law, when you apply, say, a statute, it is not done mindlessly. You do not do it mindlessly. You do not do it clerically, right? There is the need for these laws to be interpreted, right? And the judiciary interprets the law. So let us say there is something written in the law. Now, what is the meaning of these laws? What is the meaning of what is written? That is something that the judiciary does for you. This is what we understand as the interpretation of statutes. Okay. Who is the person who interprets the statutes in our country? It is the judiciary. All right. So I hope you've got this point. Finally, what we need to know is that the judiciary resolves disputes. What does that mean? If there is a dispute, it means there will be parties to a dispute, right? You must remember that the judiciary operates by resolving disputes, which means two people should come to the court, two or more people should come to the court. These are the parties to the dispute. And they have a problem with something. So it's like there is one person, let's say the person is A, he has a problem with something, and there's the other person who says, no, no, I want it to stay this way. The two people have a dispute That's why you find that the name of almost every case, every judgment, is in the manner of A versus B, right? This is versus. It's like a fight. It's a legal fight. It's a legal battle. That's why we call it a legal battle. Talking about versus and about who the parties can be, I want to give you one important point. In fact, well, two important points. If you find it a little complicated, don't worry. It's very simple. The first is I'll talk in terms of criminal law. You know what criminal law is? Criminal law is the kind of law that deals with things that affect everybody. I'll make a distinction between criminal and civil. Today we'll learn one more important difference, the difference between criminal and civil. Okay. Criminal law is the law that relates to some things which shake the conscience of the entire society. You know, you may have heard this quote by Martin Luther King. Martin Luther King. So what he said is that justice, injustice to anybody, well, he said injustice anywhere is an injustice everywhere, or something like that. I'm not very sure, but what he kind of said was that if an injustice is done to one person, I'm not exactly sure of what Martin Luther King said. Just go and have a look at that. He said something on the lines of injustice done to one person is basically injustice done to every person, right? So, for example, let us say, I'll talk about criminal only, criminal matters. Let us say there are many houses here. House number one, building number one. Here you have building number two, you have building number three, building number four. Okay, this is the road. Okay, this is the gated colony. Here's your security guard. Okay, now let us say there is a burglary that happens. Burglary means, let's say there's a kind of theft that happens in building number three. Now, the theft or the robbery or the burglary has happened in building number three, but does that not cause a problem and a fear in building number two, building number one, and building number four? You see, the act has happened here, but the tremors can be felt here as well. You get the point? So, that is the nature of criminal law. Let us say somebody is murdered here, everyone gets scared. Okay, which means that criminal law is the law that jolts the jolt, okay, that jolts the conscience of the entire society, right? It scares everybody. But let me give you another example. Let us say what is civil matters. I'll talk about how civil is different from criminal. In the same scenario, the same gated colony, we have building number one, we have building number two, building number three, building number four. Like I said, now each one of them has their cars. Okay, each of them has their cars standing outside, parked here. I told you that in criminal law, let us say if building number three, his car is stolen, then everyone gets scared. Oh my God, even my car could be stolen. This is criminal. But I'll talk a bit about civil now. Okay. Let us say in this house, let us say in building number two, for example, let's say in building number two, there is a divorce between the husband and the wife. Now, this is again a dispute, a problem that has happened. But does it scare building one? Does it scare people in building two? Does it scare people in building three? We all know that, okay, this is a matrimonial dispute. It is their problem. Their problem will not trouble us. The husband and the wife are bad to each other, but when the husband meets here, he'll be good, he'll be good, he'll be good. When this wife meets him, she'll be good. So we know that a civil dispute is of the nature of a personal matter, right? So all in all, if I were to summarize for you, when we see a criminal matter, A criminal matter is a matter that goes against the society, an act that goes against society. Whereas a civil matter is something that goes only against an individual. Is that okay? It's simple. Take a moment. If you've not understood it, just watch this once again. Everything else you can ignore, even if you've understood this much, that civil matters relate to individuals and criminal matters shake the entire society. If you've learned even this much, good enough. Now, why did I tell you all this? To tell you who the parties would be. I said, right? You will always have parties to a dispute. So, in criminal matters, one of the parties will always be the state. By state, I mean either that state or the government, the union. Whenever I say state, do not think in terms of Andhra Pradesh, Telangana, Madhya Pradesh. I don't mean that state. By state, I mean the country. Okay, it could mean either the it means the government. It could mean either Madhya Pradesh or it could mean the whole of India. Okay, in criminal, you will have one person who is the accused person versus you will have state of whatever. Okay, it could be Maharashtra or it could be versus the Union of India. Remember that in a criminal matter, since the entire society is shocked, one party will be the government, okay, the state. But in civil matters, okay, in a civil matter, it will be A versus B. Husband and wife go and fight. The state is not bothered. But in criminal matters, the state is bothered. It's an important point, an important distinction regarding versus. Finally, we come to the last topic for today, which is the Supreme Court. Okay. With regard to the Supreme Court, we need to know that the Supreme Court is the final interpreter of the Constitution. What do I mean by the final interpreter? You remember we saw a little diagram. We saw a little diagram where I showed you that there's a hierarchy. So there's a hierarchy. At the bottom, you have the district court or the sessions court. You go higher, you have the high court, and then you have the Supreme Court. Let us say a person went to the district court. Now, either they could say yes or they could say no. The district court said yes. He didn't like it because he wanted this one, so he goes in appeal. The High Court also says yes. Okay. Then he goes to the Supreme Court and the Supreme Court also says yes. Now, what can he do? Nothing. He has to accept it because the Supreme Court is the final interpreter of the law. Once the Supreme Court says something, the matter is final. Okay, it's important for you to know that the Supreme Court is the final interpreter of the law. It is the apex court, it is the final interpreter of the law. There is therefore what we understand as a finality in the decision of the Supreme Court. The Supreme Court's decision is final and binding. Okay, very simple point. I hope you've got it. The Supreme Court is the highest court, therefore its decision is final and binding. Next, I want to talk to you about this concept of a bench. I hope you realize that the Supreme Court is the final authority. Now, isn't this scary? Let us say somebody's taken your money. Okay, somebody's taken your money. So you first go to the sessions court, the district and sessions court, then you go to the high court, then you go to the Supreme Court. Now, all the three courts say no, you will not get your money back. What do? Is that not a problem for you that even the final court has said no? Now, this to make matters a little easier and a little more uh, just, what happens is that instead of one person deciding at the Supreme Court, so instead of one person deciding should there be a Ram Mandir, Should women be allowed into Sabrimala? Should triple talaq be allowed? Should we allow just one person to decide it? We say no. We don't let one person decide. Instead, we have a bench. Simple. When you have a bench, you have diversity of opinion. Very simple. So you can say, I don't know which quote this is. I just took this from the internet just to show you some diversity and to clarify the point that let us say if the matter is placed between three people, you get some diversity. When there is a bench, there is at least some amount of, there's the consolation of justice because it is no longer arbitrary. Remember this word, it's not arbitrary because there are some people who are deciding together. It's more likely that the decision will be right. Okay. Having understood the fact that there is a bench means that there is more than one person sitting on that bench. Okay. So you ideally think of this person here with the wig deciding here in the courtroom. There is one person here, and he's deciding. This is what you think of the courtroom scene, your typical courtroom drama, and people sitting here and watching the proceedings. Well, when you talk of a bench, then what you're thinking of is that it's a long bench. Okay, you have quite a few people who sit together and decide. All right, so this is what we have here. We have five people sitting here. On one side, you have one litigant. On the other side, you have the other litigant. You might have noticed I used the word litigant. It's another word that I can say instead of party. It's the same as saying party. I just use the word litigant. Don't worry. I just use different words for the same thing. Okay. Now, what is the significance of a bench? Let us say this person wants a yes and this person wants a no. Now, their lawyers will come and plead before the court. He'll say something, his lawyer will say something. They'll listen to all of this. Now you have five judges, one, two, three, four, and five. Let us say the judge number one thinks yes, judge number two thinks yes, judge number three thinks yes, judge number four thinks yes, judge number five thinks yes. The decision finally will be yes, because all the judges thought yes. But you know what can happen at times? Sometimes judge number one may think yes, judge number three may think yes, judge number five may think yes, but judge number two thinks no, judge number four thinks no. What happens now? In such a case, we do a counting. We go with the majority judgment. Now, what that means is since three people have said yes and two people have said no, we take the final decision as yes. I hope you get the point. Majority means that let us say if we had five judges, three said yes, two said no, we decide that the bench has said yes. This is what we call the majority. On the other hand, if we think of it like this, now we had these five judges, judge number one, two, three, four, and five. Okay. Let us say judge number one said Ram Mandir banna chahiye. Judge number two said nahi banna chahiye. Three said banna chahiye. Four said nahi banna chahiye. Five said mandir wahi banao. Okay. So you had this little game that was happening, and you've arrived at arrived at this decision. Okay. Now, as you can see, as far as the numbers go, this is higher, which means that we will have the temple. So the decision is by majority that the temple would be built because three have said yes and only two have said no. Okay. Now, the ones whose decisions are in concurrence with the majority decision, these are called the concurring decisions, correct? So, Judge 1, 3, and 5 have concurring decisions, clear? On the other hand, the judges 2 and 4 who have gone against the majority decision have what are known as dissenting judgments. Very important. So, what do we understand? We understand three things. Whenever there is a split decision, right? So, you have five judges. Whenever there is a split, you go with the side of the majority. Okay. Those judges who were on the side of the majority are said to concur and they give their concurring judgment. Those who are not on the side of the majority give their dissent and therefore they give what is known as a dissenting judgment. This was an important point that I wanted to tell you. Okay. Finally, for today's class, as we conclude, I will talk about what is known as striking down. You see, I want to talk about this term that is called ultra vires. Okay. What this means is something that is not according to. All right. So when I say ultra vires, this is actually a Latin word. So if you don't know it, it's okay. Perhaps I have not pronounced it correctly because again it is Latin, but I just used this fancy word because we are supposed to know fancy words when we are studying the law. Ultra vires basically means not according to. Now, why did I discuss this word? Let us say there is a section 100, let us say section 100 of IPC, for example. It is not according to the constitution, which means it is ultra vires the constitution. Okay. Which means it is not in accordance with the constitution. We had seen earlier that every law must be in accordance with the constitution. This means it has to be removed. This act of removing by the court, right? So when something is ultra virus, it is struck down. Okay. And this is something which is done by the court. Very important. Remember that when I said amendment, you remember who does the amendment? The amendment is done by the parliament. Okay. So if the parliament wants, it can remove something, it can repeal something, it can delete. The Supreme Court, on the other hand, can do what is known as striking down. For example, you know that section 497 of the IPC, which deals with adultery, was recently struck down. Who struck it down? It was struck down by the court. Okay. So I hope you've got an idea of what we've studied today, right? We've seen several things. I hope you've understood the meaning of all of these words. Let's just quickly have a look at what we've learned today. I'll just show you on this page because everything is given here for us. We started off with some preliminary concepts. We understood what legislation is. We understood what a judgment is. We understood that law is not just legislation and judgment, but also customs and traditions and religion. Okay. Thereafter, we had a look at the Constitution. The Constitution is the fundamental law of the land. We saw some important provisions 14, 19, and 21, which I want you to go and check. We understood what an amendment is. Then we learned some concepts like the independence of the judiciary, hierarchy in the judiciary, the meaning of interpretation. We also saw that in resolution of disputes, you always have two parties going to the court, A versus B, and therefore you will have some people who are in the court as disputing litigants, A versus B, or A versus the state, etc. Then we discussed a few things about the Supreme Court, about the supremacy of the Supreme Court. We discussed what a bench is, and we spoke about striking down. So I hope this lesson made some sense to you. I hope it was of help. Thank you so much for your patience.